Hi, everyone. I think we're going to get started. We're already a few minutes late and we are already between you and lunch. So we don't want to prolong that too much or run over. Great. I'm Amanda Lewis, for those of you who don't know. I was at the FTC for about 10 years and I was in mergers 4. So have a lot of experience looking at mergers and applying the 2010 merger guidelines. And then on vertical mergers, we actually as staff pretty much didn't have any guidance. So I remember looking at Steve Salop's work to just have some framework for what we were supposed to do in those cases. So as a former staff attorney, I think it's really helpful that the new merger guidelines provide some more concrete direction to staff, and then transparency to the outside community about how the agencies are going to look at these mergers. I think a lot of people have referred to this panel as the vertical merger panel. I hope that we can also and I think we're going to talk a little bit about other types of just non-horizontal mergers, because it's not just horizontal or vertical. And I think as John will probably talk a little bit about labels, those labels are not always helpful. So let me introduce our panel. I am going to try to make this brief, although I'm sure you can look on the website or their LinkedIn pages for all of the amazing other stuff that they have done. But in the interest of time, I'm going to keep the intros a little short. So first we have John Newman. He is, as of last Friday, professor at University of Miami School of Law. And directly before that, 2 weeks ago or so, he was deputy director for the FTC's Bureau of Competition. And John graciously stepped in for Ken Merber, who had to drop out at the last minute. Not going in order here, but well, I can actually. All right. So next we have, I can improvise there. Next we have Bob Lande. He's the Venable Professor of Law Emeritus at the University of Baltimore Law School and a director at the American Antitrust Institute. Then we have Marissa Beck, who is an economist at Charles River Associates. Then we have Harry First. He is the Charles L. Dennison Professor of Law Emeritus at the NYU School of Law. And of course, last but not least, and with the longest title, is Emilio Varanini, who is the Supervising Deputy Attorney General of the Competition Unit of the Healthcare Rights and Access Section of the California AG's office. And he was formerly in the antitrust section for the California AG. So I think, in the interest of the theme of not sticking too strictly to labels, our panel, we're going to go a little bit, I think, outside the bounds of just speaking about non-vertical mergers, and in particular, Bob's comments will probably be more generally applicable, but hopefully you will all find it interesting. So with that, I'm going to turn it over to John to give some opening remarks.
All right, well, thank you, Amanda. Thank you to the organizers. This is my first time here in Utah. It's a wonderful setting, discussing a topic that's, I think, near and dear to all of our hearts, and certainly those who have been at the agencies over the last couple of years. Give standard disclaimer, of course. It gives me some pleasure and delight to announce that I am no longer speaking even as an FTCer. So now I'm free to say whatever I want, which is great. I'll try to keep this lively. So of course, not reflective of the views of the FTC or the University of Miami, maybe not even my own views for that. try to be a little bit provocative since we're in between you and lunch. So I was asked here, as Amanda said, as a new entrant and an imperfect substitute for Ken Merber, who played a really, really pivotal role in shepherding a lengthy, complex process that I think had a lot of cooks in the kitchen because so many people care so much about these guidelines. As we heard during the previous panel, I think Rebecca said, these are really, really important, not just in the context of merger enforcement, but really as a statement of, the views of the agencies rather. And the agencies are not just lawyers, right? They're lawyers, they're economists, now they're technologists. They're really a variety of expertise in the different subject matters that were brought to bear on these guidelines. And I think they really reflect that. So I'm going to do a little bit of an impersonation of Ken. It's going to be really poor, as I said, imperfect substitute. I'll talk a little bit, though, at the outset from my scrawled out remarks that I put together on the plane yesterday night after finding out that I was doing this. One of the really lukewarm takes that I've seen floating around Twitter of late is that, there's actually really not that big of a difference between these administrations and previous ones. Not a hot take, right? It's a lukewarm one because, man, if there's any subject matter where it's immediately and abundantly clear that there is a lot of daylight between this administration and previous ones, it's with vertical mergers, right? Prior to 2021, the FTC had not litigated a vertical merger challenge in my lifetime. And they hadn't blocked one in more than 4 decades. That's a long time, right? That's a long time. I used to skip over vertical mergers when I was teaching antitrust, probably like many of us, or maybe I'd spend a few minutes saying, there are these things called vertical mergers. You might get slapped with a, behavioral remedy, but you're going to know that structural relief isn't on the table. So you're going to come to that bargaining table feeling like you've got a lot of leverage if you're one of the companies trying to get the deal through. And so that was basically what I would say. I should say vertical mergers are going to go through. They might get stuck with a behavioral remedy, but it's probably not going to be that onerous because you're going to know that the other side isn't wielding that big of a club against you. So that was pre-2021, 0 litigated challenges at FTC in 40 years. At one point in 2022, the FTC was litigating 3 vertical merger cases at the same time. That probably hadn't happened since the 60s, if ever. That's a change. That is a serious sea change in an approach to a really important subject matter. We effectively blocked 2 of those, NVIDIA ARM and Lockheed Aerojet. Companies abandoned. The other one's Illumina Grail, which was voted out while Commissioner Slaughter was acting chair. The commission has now found that that was an illegal vertical merger. That one's up on appeal to the 5th Circuit. So you've got 2 out of the 3 blocked. The other one resulted in, I think, a really nice commission opinion. The first judicial, I'll call it, right? Quasi-judicial in the case of an administrative agency, but basically judicial opinion, finding a vertical merger was illegal in a long, long time. So making history, and these are important cases, right? They aren't just bringing vertical cases for novelty's sake, but these are really, really important mergers. In the case of Illumina Grail, you've got potentially life-saving technology at issue. Lockheed Aerojet, you've got national defense, right? Security at issue. And then NVIDIA ARM, semiconductors are like the lifeblood of our economy at this point, right? And so you've got control over really critical semiconductor markets at issue. So super important cases that would not have been litigated under previous administrations that were litigated. And again, in 2 out of those 3 cases yielded blocked deals. It like boggles my mind when I sit back and think about how different the world was such a short time ago. 2019, I was teaching antitrust. 2019, I skipped over vertical mergers. I may have said, there was also this AT&T Time Warner case, but kind of an anomaly. Today, I cannot do that, right? I think the agencies have, if nothing else, created a lot more work for law professors trying to figure out how to cram all of antitrust into the survey course because there's more of it. And I think that's a really good thing. So what changed? I mean, what drove that change? I think it was a 1-2 punch of law and economics. in keeping with the long tradition at the agencies going back before the Chicago School, right? Economics existed at the agencies before Chicago's particular viral strain took over and infected the agencies. But that's what happened again, right? Good law, good economics. And really with the vertical stuff, a big part of what we did was unearth a strand of case law that had been basically forgotten, had been covered in a pretty thick layer of dust. And it started with the brown shoe case, which we're all familiar with, and agency enforcers use all the time, including during the Chicago School era, right, for market definition. There's this practical indicia framework for market definition, the brown shoe framework, that everybody's familiar with. So the staunchest conservative to the most fire-breathing neo-Brandeisian. Everybody uses that. Everybody recognizes its use is valid, right? It's grounded in the law. And it serves some really practical purposes, right? The practical indicia approach to market definition can be very, very useful in cases where a hypothetical monopolist test just might not be workable. Maybe the market's too new and prices haven't had time to fluctuate and produce some usable data. So there's this usable part of brown shoe that we're all familiar with. There's this other part, this vertical merger liability framework that just basically got forgotten. It got excised from edited versions of brown shoe in case books. Won't name any names, but even folks who taught vertical mergers really taught like ability incentive and didn't teach the old brown shoe framework. Yet when you look back at what the Supreme Court said about vertical mergers, they didn't say, oh, these are way different and should be treated under some different standard than horizontal mergers. When you look back at what the Supreme Court said about vertical mergers, it said, I'm quoting now, all mergers are within the reach of Section 7 and all must be tested under the same standard, whether they are classified as horizontal, vertical, conglomerate, or other. Now, that's from Procter & Gamble, a case that some people don't like on ideological grounds, but is absolutely good law, right? Has never been overruled. Okay, so with that in mind, right, what the Supreme Court said is, hey, same standards apply under Section 7, whether you're classifying something as horizontal or vertical or conglomerate or other. I think that kind of evinces a really smart, really pragmatic approach that the Supreme Court was using at the time, where they're saying, like, let's not let the labels get in the way of the analysis. And I think, as Amanda previewed, that's something that you see in these draft merger guidelines. They don't let the labels get in the way of the analysis. And definitely true of the, what I'm going to call, because labels are sometimes useful, the vertical portions of the draft merger guidelines. They really don't, hammer you over the head with that language. They talk about non-horizontal mergers. And I think vertical, although it's become really well accepted as a label, it does have some downsides. And one of the biggest downsides is it gets you thinking that some kind of different type of harm can arise from vertical mergers as opposed to horizontal ones. But of course, the harm is exactly the same, right? You're concerned about a loss of competition either way, horizontal competition either way. It's just that the supply chain relationship may be a little different. So the general draft merger guideline approach, I think here, and I'm cribbing from Ken's notes, so forgive me if this is a little clunky, but is to do away with trying to break free of labels like horizontal, vertical, and to the extent possible, rowing upstream here, because there's been a lot of discussion and discourse and some cases that use those labels, but really trying to refocus on the actual nature of competition in this involved, implicated by the specific merger at issue. A thing that I've heard Jonathan Cantor and others at DOJ say over and over and over is, we look at how competition actually presents itself in the marketplace. So shifting focus to guideline 5 specifically, which is the one that really, I think, clarifies, but reifies in a sense, the ability and incentive framework that had kind of floated around, as Amanda said, kind of lacked former merger guidelines on the vertical front for a while. But the ability incentive framework showed up in commission and DOJ settlements. It was used in the AT&T case and endorsed by, I think, Judge Leon as a sort of viable pathway. He just found that to his mind, none of the facts were there. So there's this viable pathway out there, this ability and incentive framework. It's a little newer in vintage than the Supreme Court's brown shoe framework, but it's been endorsed by at least some courts. And it does offer, I think, some nice analytical clarity. It keeps the focus on competition. It's less structural in nature than some of the other guidelines we'll talk about. Really to run, I'm looking at the economists in the room to correct me if I get this wrong, but to run the vertical math and do an ability and incentive test, you really don't need to assign market shares. You really don't even necessarily need to define a market. You just plug some numbers into a math model. Oh, there's quibbles to be had with that as an approach, I think. My good friend John Quokka and former FTC colleague is fond of calling vertical math intermediate economics, which to me as a lawyer sounds like something I aspire to, but I think John was using it in a somewhat derogatory manner. There's quibbles to be had with that as an approach. And one of the things that I think that the guidelines do a really nice job of is explaining that even within this ability and incentive framework, that intermediate economic approach of using a math model is not the only way that you can prove to a judge that, hey, there is an ability and an increased incentive caused by this merger, or there's an incentive and there's an increased ability presented by this merger. Another thing that the guideline 5, I think, does a really nice job of is making clear that we're not just looking at raising prices, not necessarily needing to find some kind of lost sales up front. There are a lot of different ways to degrade access for competitors to an important input or an important sales channel, right? And that, I think, is good economics, right? It's also good law. One of the things that I was pleasantly surprised at as somebody who's kind of classically trained in the modern antitrust orthodoxy is when you start looking at those older cases where they were actually litigating vertical mergers, there's a lot of really good, sound economic wisdom in them. And I think it took us, some decades to sort of rediscover through like post-Chicago economics and that sort of thing. But it's like these judges knew it intuitively. One of the things that I really love from an older case is the United States v. Cibron case. This is a 1971 decision, Eastern District of Pennsylvania, I think. And one of the things the court found was, given the facts at hand, total foreclosure wasn't likely. So there's just reason to think that this company, if it buys up a supplier, is not going to totally cut off access to all the other suppliers. But the court said, paraphrasing a bit, there are myriad other avenues more subtle than that. What today we say total foreclosure. And they aren't necessarily going to result in lost sales up front. It took us a while to sort of rediscover that. But today I think it's pretty well accepted. Partial foreclosure is a reality, and oftentimes it can be the more profitable avenue of foreclosure, right? And so I think that's another nice thing the guidelines do here is it's good economics, it's also good law. So that's guideline 5, the ability and incentive framework. Guideline 6, this one's really near and dear to my own heart. This is the one that really dusts off and memorializes and kind of brings up to date, but really makes clear that we're going to use this legal framework that the Supreme Court laid down in Brown Shoe. It's still good law. It's never been overruled. As recently as 1980, I think it was, the Second Circuit in a case called Fruhoff Corp., which is one that we lost, FTC lost, called this Brown Shoe framework the fountainhead of vertical merger analysis. And then it just disappeared. Right? It's kind of wild when you step back and think about how could that happen in a discipline. It's kind of bizarre. It's very unusual and unique, I think, to antitrust. The pendulum swung a long ways. I think it's swung back, and you see that in Guideline 6. So it really brings those Brown Shoe, what I call functional factors, back into play, makes clear that the agencies are going to use these. And they are important. Tying back to something that came up on the previous panel, the beauty of these functional factors is very much like the beauty of the practical indicia for market definition. You don't necessarily need an economist although it's great to have one. But you don't necessarily need an economist to prove up these factors, right? You can look at the facts at hand. You can use real world business documents. These are factors that lawyers and judges can understand and use, just like those practical indicia for market depth. Same idea. Hypothetical monopolist test is great if you can run it, if you have the tools, if you have the data, but it's really important that it not be the only path. And that's what guideline 6 is all about, is making sure that that ability incentive framework isn't the only path available. In the right case, I think it can be a really important one. It's much more structural. This ties back to, I think, Eric's comment toward the end of our last panel discussion that HHIs, love them or hate them, can be much simpler to use in litigation than some of the more exotic tools out there. Now, this framework doesn't necessarily depend on HHIs. If your market share is high enough, if you've got a 50+% market shares, there's a presumption there that your vertical merger is illegal. I think that's good economics. It's also another one that's good law. You take a look back at Brown Shoe. It said if the foreclosure share from a vertical merger is at or near monopoly proportions, this merger, of course, violates the Clayton Act. I think this is an area where the guidelines could have gone even further and just said, this was your idea, Eric. They could have just said outright, those mergers are illegal. And it would have just reflected the Supreme Court's statement. It wouldn't be making law. There's something to be said for a pragmatic approach, recognizing it is 2023, and if you do go too far, you're going to get bench slapped. So I like the approach here. I think it represents a little bit of a compromise, but a really important one because it's structural, because it's simpler, it's easier. A judge can understand it, a lawyer can do it. Guideline 7. So this was an attempt to really take on a kind of criticism, a kind of a myth that the FTC is going to use this to challenge a merger where the one effect is to make the one firm's product better. I just think even from a litigation perspective, that would be a bad case to bring. If all you have is, hey, this merger is going to make one of the products better, that it's not going to work. I think Rebecca drew out a really important point on our earlier panel that there can be cases where it looks like if a product isn't necessarily better, it's like at least consumers like it more. I might say it that way, the Microsoft Activision example. It's not like Game Pass is a better product, but consumers like it more if it has more games on it. But that's a short run effect. There can be harms in the long run. But really this guideline 7 is kind of trying to defuse that criticism that, oh, the agencies just don't like mergers that make better products. Okay, so it's a basic overview, I think, of the main guidelines that we want to talk about. I want to step back just a little bit. Did I do my 15 minutes?
You just want-
Okay. Let's keep going.
We
Just
got
kind of trying
clarity.
to fill up my 15 minutes. So a quick step back. Thank you, Amanda. I think it remains to be seen how all this will play out in courts, right? It's early days. But I would keep an eye on that Illumina decision that's on appeal in the Fifth Circuit, that the commission laid out 2 of these pathways really nicely. See what the Fifth Circuit does with it. I think we got a pretty good judge draw there. So a decent chance. Microsoft Activision's obviously another big one to watch. Keep an eye on that Ninth Circuit opinion. But also people forget about some of the cases that don't get as many headlines. IQVIA is another one. The FTC is litigating right now. It has a vertical theory in it, and it kind of just flew under the radar. I think this is not a big tech case, but there are a lot of things in the works, a lot of torpedoes in the water that make this, I think, a really lively and timely topic.
Great. Thank you. That was great, especially last minute stepping in and all things considered. So I think we're going to start with Bob as we bring in the other panelists into the discussion. So John just spoke a lot about how the guidelines explain how the agencies will interpret Section 7 and some of the case law and economics behind that. You've been doing a lot of work on what we can learn from a textualist approach to Section 7. And so can you tell us a little bit about your work, and starting with the maybe maybe substantially to lessen competition, to get it right, since we're talking about textualism, part of the statute.
Thank you very much. Can you all hear me, or should I get a microphone? Get the microphone. Okay, sure.
And they could hear me say that.
The analysis on textualism I'm going to present applies whether we're talking about vertical mergers, conglomerate, horizontal, any merger. Actually, it's work that I'm going to be finishing up together with John Newman. So it's nice coincidence that you put us right next to one another. As you know, and by contrast, a traditionalist approach to statutory construction interprets the laws according to their legislative history, especially in cases where the statutory language is ambiguous. But to a textualist, legislative history is completely irrelevant. A textualist starts, and in almost every cases stops, with the exact precise words or phrases in the statute. Now, for a number of reasons I don't want to go into, I'm not a textualist, but for those of us who used to think that textualism was the quirky attitude of Justice Scalia and a few academics, that era is long over. Textualism has embraced many members of the Supreme Court totally, and once in a while, every member of the Supreme Court says they are using textualism. So briefly, what does a textualist do? Well, first, they find out how dictionaries, especially English language dictionaries and legal dictionaries and legal treatises, interpreted key words and phrases at the time when the statute was passed. Second, they stop. Textualists don't add anything into the law that isn't a fair, ordinary, and straightforward interpretation of the plain words and phrases in the statute. In particular, textualists do not add exceptions that are not in the statute, and they do not impose their own policy preferences in the statute. All they do is interpret the plain words of the statute at the time the laws were enacted. And Scalia wrote a 560-page Bible of textualism, contains a lot of complications, none of which affect what I'm about to tell you. But one of the things it does contain is lists of dictionaries and legal treatises and legal dictionaries that Scalia considered reliable and authoritative for various time periods. And I'm just going to use Scalia's lists of authoritative dictionaries and legal dictionaries. I want to just give a prelude of what I'm going to talk about by giving a 2-minute summary of what I said at this conference a year ago, when I gave a textualist analysis of may be substantially to lessen competition. What do those words mean from a textualist point of view? And the answer is, it turns out they mean exactly what they mean today. Those words haven't changed their definition in 100 years. So what that means is the phrase may be substantially to lessen competition calls for a very interventionist approach to merger enforcement. Now, if you look at the lower court decisions, some seem to follow that language. But just to give one example of a court that didn't follow that language, was the Baker Hughes opinion by then Circuit Court Judge Clarence Thomas. He asked, and this is a quote, whether the acquisition will substantially lessen competition or to pretend to create a monopoly. So he changed the word may to will. Now you heard, I guess it was Susan who talked mostly about risk and risk analysis. Well, what happens to your risk analysis if the judge who claims to be a textualist judge changes the word that Congress chose from may to is going to substantially lessen competition? Well, what does that do to your risk analysis? What does that say about good judging versus bad judging? Whatever that is, it's certainly not textualism. And maybe I'll shut up for the moment.
So we're going to get more, or in particular, you are going to get more to the tend to create a monopoly language shortly. But for first, I'm going to pose kind of a broad question, but interesting and an important one to to the panel. And so I want to ask everyone to weigh in on what do you think are the most difficult or challenging aspects of correctly assessing whether a non-horizontal merger violates section 7. And I'm thinking about that from multiple points of view, and you can choose your own adventure here. But thinking about this from the point of view of staff, also from judges, from merging parties counsel, and economists. And then I want you to also address, if you can, how do the draft merger guidelines help address the problem? And how effectively does it do so for whoever you think the target audience is for the guidelines? So we'll start with, if we can start with Harry, and then.
Hey, why
Emilio
not?
for your second.
Okay. Can I comment on everything that went before in the first panel? Well, I'll do that as we're going, and I'll comment on Bob, but I was waiting to hear the second part. I want to take up your point about problem identification. So what's the problem? And sort of combine it with, oh, but we don't like categories, so we don't want to think horizontal, vertical, conglomerate, sideways, upside down, diagonal. Some categories are both helpful and inevitable. Judges need them. They, if you're going to analyze things, and this is one of my problems actually with the current draft, which is I'm not sure how well they help judges analyze a merger problem. So I think of this as a teaching effort, and what's the analytical structure for a merger problem? So and that tends to, well, we need 3-part tests. We need step 1, we need step 2. Those sorts of things are very helpful in guiding a court and guiding lawyers in presenting things to the court. So I'd like to see a little more of that. And I'd like to see a little more of the lawyer's trick, which is presumptions. Make it clearer when you're shifting the burden of proof to the defendant, particularly when you shift burdens to the defendant that they can't meet. Those are the ones I like the best. But that's the lawyer's trick. But as an analytical structure, I'd like to see more of that. But I want to step back again to the problem identification issue, which is not necessarily related to the category of analysis. Even in the first panel, the discussion moved from platforms, which is a real challenge for merger analysis, to horizontal mergers and HHIs. I thought we had figured that one out, but no, we're still dealing with that. So what's the problem that the guidelines are addressing? And frankly, I think one of the problems is an assumption that the Biden administration went in with, and you can see this in the executive order that President Biden issued in 2021, that merger enforcement is a big failure. We spend a lot of money on this, a lot of resources, and what do we get? More concentrated economy, continued concentration, high profits, low entry, disparate income results between labor and capital, high prices. What have we gotten from this enterprise that a lot of us spend a whole lot of time on? And I think Susan and Nancy talked a little bit about the sort of the economists. We all get involved in the models and all of this. And what do we get? Another day older. Wasn't there a song like this? And deeper in debt. The problem, and being a little more specific on these cases, is increased concentration, growth of large firms, and this has been an issue in antitrust that we sidestep, but is a policy issue, bigger and bigger firms, and the ubiquity of platforms that we've been able to do nothing about until the current round of Section 2 litigation, and we'll see whether we do anything about it even after that. So what's the first line of defense to getting to all these things, to dealing with these things? Strict merger policy, strict merger enforcement. I think that came out in the discussion. I think Nancy mentioned it in the first panel. You know, we've really got to tighten up merger enforcement. But of course, then the question is, what does that mean exactly? So I look at these guidelines and saying, well, that's the goal. We want to deal with concentration, and concentration. Susan said at the beginning that concentration is a proxy for oligopoly models. No, not for me. It's a proxy for the ability of small firms to compete. It's a proxy for democracy. It's a proxy for having a flexible enough economy that you've got 6 or 7, accounting firms. I mean, it proxies for a lot of things. So if you do a word count in the guidelines for concentration, you will find that these guidelines mention concentration or some form of it 90 times. All right, the UK's, by the way, it mentions it 16. Interesting little. Yeah, I hate to, I'm standing here telling you what your guidelines say. The 2010 guidelines mentioned it 45 times. So there's a flip in the sort of the emphasis in the guidelines. Price, the current draft mentions price 91 times. Right, the UK's is 122. You're ahead or behind. I don't know how you want to think about that. But the 2010 guidelines mentioned price 215 times. So I think this gives you a sense of. Oh, here's another. This is I like this. SALIP is mentioned no times in our guidelines, but twice in the UK's guidelines. And Quokka gets 2 mentions in the UK's guidelines, none in ours. Now, I mentioned the UK's guidelines because guess what? There's a bigger world out there. You wouldn't know it from our guidelines that there happens to be a bigger world. And a number of the most difficult and most important cases that are under litigation today in the United States have been dealt with by the UK and by the European Commission. And we don't seem to know this. I don't know. I don't. Maybe, John, you can tell us, do they ever look and say, I wonder what the heck those guys are doing? Yeah, well, yeah.
In fact, though, I mean, the FTC and DOJ have gotten a lot of criticism for engaging too much with Europe and the UK.
Well, it would be nice when they talk about Illumina Grail to say, guess what? We're third in line. The EC and the UK have both said it's a bad merger. So now you want to say it's a good one? We have to do something. That's another story. Okay. Now, economics. I do want to say something about economics because I do want to mention my wonderful friend and former co-author, John Flynn, who taught, as many of you know, at the University of Utah for many years. He was not very fond of economics in antitrust. He used to refer to Darren as Dr. Bush when he wanted to, criticize insult him. To him, antitrust was a form of jurisprudence. All right, so this was is a different lens, and he didn't think economics had the whole answer. And I thought for these guidelines, I thought there was a subtext in putting the economics in an appendix. Now, maybe I'm wrong, but appendices are things that people never read and an organ that you don't need. So I don't know if that's the message for economics, but I think one of the things to take away, and it does go to these kinds of mergers that we are focusing in on, the non-horizontal mergers, is that a descriptive analysis of how competition is occurring in these markets, which frankly, if you look at the opinions from the CMA or the European Commission's, much more, it's not that there's no economics, but it tells a much fuller story. That's really critical in understanding these markets. And it's not going to be through econometric studies of markets where prices may not exist, or markets that haven't developed yet. So there's a place for economists, but it's maybe a different place in these guidelines, and I think that's appropriate. Now, the multiple guidelines going to the vertical, I have to say, John, when you said you didn't teach vertical mergers, obviously you weren't using our casebook, which has vertical mergers in it. And I love teaching Brown shoe because it's so wrong. The decision is so easy to criticize. The foreclosure was like 2%, and the court found it illegal. I mean, 50% is wonderful, but I don't see a case actually that has been 50%. So I don't know what to do with that in terms of the law. I think the foreclosure story, just qua market share, is a hard one to make unless you go further and explain the industry. And that's what the incentive and ability test does. I think in guideline, I always get the numbers confused. We're already talking about numbers. Oh, it's guideline 6. Guess what? You don't know what that is? Better take my class. The vertical merger guideline, which says we're going to look at fair opportunity to compete. Okay, what does that mean exactly? But a strict market share gives us comfort. I wait to see the case. I wait to understand what it means exactly. And I don't think it's going to convince courts in particular. So now the cases that I actually do have in the case book and stopped teaching was potential competition. Because that it was too difficult. The doctrine was so awful and so adverse to plaintiffs, and the cases, no one was bringing any of the cases, that I stopped wasting students' time with it. So those were the cases I stopped. Fortunately, they're still in the book, so they're there. You can teach them. That's and they're relevant now, right? In a very unfortunate way, as the commission found. One last point about institutions, which Andrea mentioned. We do have an administrative agency, and John referred to it, that can decide cases and can write opinions that have that breadth. And we do call that, what was the name of your agency which you used to work for? The Federal Trade Commission, which in Illumina Grail, the chair wrote a excellent opinion. The ALJ, of course, just the case, but wrote a very good, thorough, comprehensive opinion. And that is a way of dealing with an institutional problem that we do have, of litigating before skeptical judges, who forever, let's start in 1914 and go forward, have been skeptical of government merger cases forever. And we can look at Philadelphia National Bank as an example. They always decided against the government. So more litigation in the FTC.
That was great. Emilio?
Yes, so it's my pleasure to be able to appear here and speak to all of you. Of course, my remarks are on behalf of myself only and not on behalf of California Attorney General's office, other state enforcers. I think we have a couple of folks here who either did or still do work for the Utah AG's office. Always a pleasure to see you. So my remarks are not representative of them either, or my federal counterparts with whom we enjoy a great relationship and enjoy working with them. So I'm going to depart from what Harry said, which I appreciated very much. And I want us to step back a little bit about why we're here today. Okay, and so I want to start off with the textualist point. The textualist point that you're hearing about from other speakers is an extremely important one, because we've all forgotten about the textualist point. In fact, even Justice Kagan in her famous Spider-Man case in 2016 talked about antitrust law as reflecting the common law. That's true. And basically that judges could decide what rules is appropriate. Also true, but it misses the textualist argument. So why do I start off with the textualist point when it's already been ably covered by a number of the other speakers here today? Because forgetting about the text can lead economists to believe that there can be competitive issues that are out of bounds, that shouldn't be addressed, that they shouldn't think about mechanisms for addressing them, that they shouldn't think about models for separating sheep from goats, and that can make them think that no case should ever be brought in court. And so the example I'd like to use is cross-market mergers. As you've already heard from others, there is clear textualist support for going after conglomerate mergers. You can't deny that from the case law. You can't deny it from the statute. So why is it that conglomerate mergers have become such a untouchable animal that you should never be going after, rather than trying to figure out when they may be a problem, when they may lead to tying or bundling or conditioning, and when they may actually not pose any sort of competitive threat or may even be beneficial for consumers. Well, to figure that out, you do have to look at the history. And I'm glad to hear that other speakers are doing that. But here, the history about tying, bundling, and conditioning, about cross-market mergers, you have to go look at a case called GE Honeywell in the early aughts. And GE Honeywell, I know we all kind of today look at GE and we're like, GE, who are they? But back in the day, and back when I had more hair on my head, GE was a powerhouse. They were like the champion of the United States. Jack Welch could do no wrong. And Jack Welch's theory of corporate growth, aside from sort of arbitrarily cutting 5% of the workforce every year, was like, I have to cut 5%. Never quite figured that one out. His other idea was, I'll just keep building up GE through acquisitions. So GE Finance, GE Jet Engines, GE Turbines, GE Power, GE Computers. And so GE became very big in the airline industry in terms of building jet engines. And so he set his sight on acquiring Honeywell. And when he did that, the Europeans opened up a huge investigation. And they had two theories. One was horizontal overlap, which everybody overlooks, including the United States at the time. They also had a theory of time. And the fact that they were considering going after GE Honeywell on a theory of time, and the commission ultimately ruled that it would be anti-competitive on a theory of time, in addition to the horizontal issues, just caused the United States to go into an uproar. Major politicians in the US and the administration flew over to Europe to complain. This was a big thing. There were seminars like this one. In fact, there was one at Columbia that I was at when I was just a baby antitrust lawyer, where GE Honeywell was the whole topic of discussion. It led to the creation of the International Competition Network. So a good thing. But the result was, it didn't matter what the text said. It didn't matter what the case law said. Going after conglomerate mergers was uniformly bad. So what happened after that? Well, there was actually a dialogue both in Europe and between Europe and the United States. So Harry, as much as I like you as being a former state enforcer, I have to disagree with you that Europe and the United States don't talk, because they do. And over time, both within Europe and between Europe and the United States, there became a recognition that you could go after time. It's just the evidence had to be there. And you've all heard earlier from the first panel about what it means to go after the evidence. It can't just be, I have an economic model and I'm done. As much as we love the work of economists and economic models, it has to be that the qualitative evidence also needs to be there as well, that time is a real threat. So if you look at statements of the federal government and international fora, you can see an evolution on the side of the United States. Just like you could see an evolution in Europe too, we can't just say tying is a problem, be done with it. We actually need to go look at the qualitative evidence to say that tying is a real threat, that it is a real risk, right? Because ultimately, while we all agree risk flows from the text, you could argue risk is in every merger. Every merger has some risk. So you still have to separate the sheep from the goats, which is the point of the draft merger guidelines. So that brings us to today and today's draft merger guidelines. And they have in guideline 7 a recognition that you can't entrench or extend a dominant position. Now, the American Bar Association of all organizations has recognized that this flows from the case law. So if you go look at their comments on the draft merger guidelines, they don't say, oh, you should throw out Clorox. You should forget about what the US Supreme Court said in those cases in the 60s and the 70s. You know, they have some practical critiques, which is fair enough. Whether I personally agree with them or don't, I do work for the ABA, so I'll leave that unsaid. But the point is that there's now a recognition that you can't get away from the text, and rather you need to grapple with it. And at the same time, was a recognition in the economics community that, wait a minute, cross-market mergers might be a real problem. So it's not just on the legal side, hey, you can't get away from the text. Economists also started thinking about these issues as well too. And so they kind of match up nicely, right? We had this sort of divergence where economics under the Chicago School went off in terms of this is what we think the rules should be regardless of the text. Post-Chicago School came back in and said, well, you need to rethink at least some of that. But people have gone about the text. The draft merger guidelines do a nice job of bringing them both back together. And they're already changing things in ways that I think are bipartisan. So a lot of people talk Biden administration this, Biden administration that. But you saw the beginnings of these evolutions under the Trump administration. They brought a vertical case. Their vertical guidelines, well, you know, speaking personally, I would criticize certain aspects of it, were a dramatic improvement over what one would have expected had it been a Chicago School individual who wrote them. And so I think there was a bipartisan recognition due to looking at the text, due to being more rigorous about the economics, and due to 30 years of understanding that in terms of the economy, this idea of consolidation leading to economies of scale hasn't exactly worked out. That was the point of the resilience discussion that you all heard this morning. And so where am I going with all of this? Horizon Amgen. And so Horizon Amgen is a pharmaceutical merger. And this pharmaceutical merger involved Horizon, which makes orphan drugs. Okay, so orphan drugs basically have a monopoly, but there are competitors that will be coming into the market within the next 3 years or so. And so the worry was that Amgen, which already engaged in exclusionary rebating conduct, allegedly, would take that conduct and extend it to Horizon's drugs, so that way competitors would never be able to get onto the formularies. So for those of you who suffer from a disease for which these orphan drugs are basically the only treatment, you would have no alternative but to continue to use the extremely expensive. If you ever go look at orphan drugs online, they are hugely, hugely expensive. Now that's not a bad thing. You know, they get exclusivity initially for a reason because they're treating rare diseases. But at some point, you know, enough is enough. That's why the monopolies are supposed to be limited. And so in that case, the FTC got behavioral relief, which is unprecedented in terms of its impact and its extent. Now, I wanted to say, to be fair to the parties, they recognize that there might be a problem. They proposed a fix-it-first remedy, and one can contrast that fix-it-first remedy, which was more limited, with what the FTC got, as supported by states such as my own. California was a signatory to that settlement. Now, if you go look at Law 360, you would think the FTC lost. It was like, oh, the chair settled for behavioral remedies. Said she would never do that. But that's not what actually happened. What happened here are unprecedented behavioral remedies to deal with the prospect of tying or bundling that really will take that off the table, that take the party's word and say, okay, if you really mean what you say, we're going to make sure it's effective. And so getting back to the draft merger guidelines, we wouldn't be here today if it wasn't for the fact that the draft merger guidelines supported what the FTC and states like California were doing. And that's ultimately what the draft merger guidelines do here. They bring in this textualist stuff. That's why they cite the case law. They are saying, we forgot about that. But they're updating it with both sort of the evolution of Chicago School, the post-Chicago School, and then I guess the post-Chicago School, I don't know what you would call that, as well as sort of our better understanding of the economy. I mean, think about it. The economy today in 2023 looks a lot different than it did, say, in 2008 or in 2010. It is a vastly different economy, and we know a lot more. And so that's why I think the draft merger guidelines, speaking for myself, although my state has joined multi-state comments to support them, I think they're a good thing on the whole. And I think the American Bar Association recognized that on the whole, as have states. And I think my federal counterparts, speaking personally, because that's all I can do here, are to be commended for what they've done. And I think you all as economists and policymakers can do a lot of good by building on that and by helping the federal government and helping states to build on that, to help build better models of cross-market merger analysis, to help do additional studies to really buttress that out, because now you have the opportunity to do that thanks to these draft merger guidelines.
Thanks, Emilio. Thank you. Thank you so much for that. Marissa, I'm gonna give you the option. Do you want to talk about efficiencies now or a little bit, or do you want to? Do you want to do briefly?
Sure, I'll go brief.
Okay.
So, as Amanda previewed, can everyone hear me okay, by the way, with the mask just, all right. So, as Amanda previewed, I think one of the biggest challenges with respect to non-horizontal mergers is this kind of myth that almost all non-horizontal mergers have these gigantic efficiencies, and so they're beneficial. And where does that come from? Comes from this fundamental difference between combining substitutes, right? That's bad. And combining complements, which we say, okay, that's good. And it is, except the real world's not nearly so simple as this little economic idea we have going on here. And I think, as Susan said, once you kind of, if you just think about two goods and they're complements and you're combining them, that would be a good thing. But once we add a rival to one of those goods, suddenly you're buying the complement that is also a complement to your rival. And that leads to these countervailing factors. And so as economists, we jump all over this, of course, and we want to analyze this and put a lot of numbers on it. And, we've done this for many, many years. And there's a lot of literature about benefits of vertical integration. But I think the challenge is that some people take that to read, well, there's all this literature of this benefit, and that means that almost all vertical mergers are beneficial, and we really shouldn't be worrying about them. So I guess just to say, I won't go on for too long, but just to say a little bit about that, that is not my read of economics literature as an economist. It is definitely the case that the literature finds benefits. It is also the case that the literature finds harms, because essentially these mergers have the same effects. They have these horizontal effects. They're doing the exact same thing of combining, well, not literally combining, but you're losing horizontal competition. And so if you look at the recent literature where we have a lot more sophisticated techniques for dealing with this, you'll see that really there's just as much evidence of harms as there is of these benefits. And most importantly, most of the literature doesn't do this full balancing that one might get the impression from the 2020 vertical merger guidelines that was necessary. So I think it's really important that we not place this burden on merger enforcement that's so high and even higher than what we're doing kind of in the academic literature, and not take that literature to imply that we shouldn't be enforcing this stuff. And I think that that's really what that's what these guidelines are trying to do, to put this all in the same framework and not make this distinction between these cases are horizontal, these cases are vertical, so just don't go worrying about those. And instead try to focus on, can we identify harms? And if we can do that, then we can also think about, okay, well, are there efficiencies that should also be coming into play here? I will say, I was just going to say, I will say though, I don't think any of that means that we should get rid of the Economist. I know we have this, and I'm personally offended, by the way, that the economics, a lot of it is in the appendix, although that's not really true, because the whole ability and incentive analysis, that is economics, okay? But I don't think you can get rid of the Economist. I understand it gets difficult, especially when we start to sort of quibble over the details of analyses that are far past the intermediate economics that we were referring to before. But I don't think that means that we should just throw out the Economist. And actually, I think this is really critical, because probably most people here have been in, say, interviewing a customer about a merger, the customer. And you ask the customer, well, okay, what alternatives do you have, right? And they tell you, well, merging party A, that's like one really that's one of my main suppliers. And the other guy I'd really go to is merging party number B, great supplier too. And you say, okay, well, are you worried about the merger? And they say, no, right? And sometimes I think that we can't we don't want to let that kind of testimony, like what happened in Sprint T-Mobile, kind of override the economic incentives. They're really important here, even if they're complicated. And we need to find ways to try to make that clear to judges, to really teach them what they should be looking for, rather than kind of just sweep it all away by saying, oh, these ones are so hard. We don't want to put judges in a situation where they feel like this is too hard and I can't understand what the economists are saying about these competing factors. And therefore, I'm just going to rely on the testimony of the business people.
Thanks. That was really interesting, and I think really, really helpful and insightful. And you wrote a paper recently, right? You want to just flag that for folks in case they want to go take a look at it?
Yeah, sure. If you want to learn more about what the economics literature says, which I'm sure you're all really excited to do that. But no, Fiona Scott Morton and I did a study of the recent literature, and this is sort of the basis of saying, look, we're finding just as much evidence of harm as we are of efficiencies, and we really shouldn't be treating it as if this body of work just says, this is all beneficial, and let's just turn the other way. We're okay with non-enforcement
Right.
stuff.
Yeah. It has like the effect of putting the burden of disproving an efficiencies defense on the enforcers. Yeah. And where can people find it?
Sorry, you can find everything online.
Okay, people, you just Google it. Yeah. All right. So I think we will turn back to Bob to your work, and you'll discuss now the 10 to create a monopoly language, and which is the new part of your work. So we're excited to hear about that.
Thank you. Thank you very much. If anybody wants the old article on the maybe substantially to lessen competition, there's some copies in the back. You're welcome to. I'll sell them at market price, which you know what that is, right? From a textualist point of view, how do we approach may tend to create a monopoly, that clause? And this should be especially relevant in unilateral effects cases, of course. Well, a textualist would analyze what the word tend, the key word in the clause, meant using Scalia's dictionaries and proceed from there. Now, the short answer to this question is tend 100 years ago meant the exact same thing that it means today. It means essentially moving in the direction of something. Let me read you dictionary definitions, because they're all just about identical from 3 of Scalia's preferred dictionary. Tend means to have a tendency to operate in some particular direction or way. To have a motion or disposition to move towards, approaching. To move or direct one's course in a certain direction. So tend, in this case, tend to create a monopoly, means simply to move in the direction of a monopoly, not necessarily to arrive at a monopoly, not even to arrive at a near monopoly. Now, this is in contrast to the Sherman Act definition of the relevant terms. As you know, the attempt standard for the Sherman Act was established in 1906, and there has to be a dangerous probability of monopoly power. Well, moving in the direction of a monopoly is different from the emergence of a dangerous probability of monopoly power. So the textualist definition is actually quite different from the Sherman Act definition of what we need if we fall short of an actual monopoly. What do the Supreme Court cases say about the tend to create a monopoly clause of Section 7? I only found 3 cases on point. They're all 3 quite interesting. International Salt. They're all quite old, though, I should add that. International Salt said, it is immaterial that the tendency is a creeping one rather than one that gallops that proceeds at full gallop. Nor does the law await arrival at the goal of condemning the creation of the movement. The DuPont case said, have brought it measurably closer to that end, for it is the purpose of the Clayton Act to nip monopoly in the bud. And finally, Brunswick said, before those relationships could work their evil. Now, lower court cases involving tend to create a monopoly are far fewer in number than the maybe substantially to lessen competition cases. There are any number of cases that merely recite the language, but they don't actually interpret it. Now, of the lower court cases that actually interpret tend to create a monopoly, many of them use the dictionary definitions, and for lack of time, I'm just gonna skip those. But what is disturbing, especially if you're taking this from a textualist point of view, are those cases that ignore or change the words in may tend to create a monopoly. For example, one lower court decision changed it to, and I quote, will result in the creation of a monopoly. Another court required plaintiff to show that the purpose of the merger is to create monopoly. Another court banned mergers that would result in a near monopoly. So would instead of may, and near monopoly instead of tend to move in the direction of a monopoly, which is what the dictionaries would suggest. And a number of lower court decisions changed may to is. They said they'd only block a merger, the effect of which is to tend to create a monopoly. So in conclusion on this point, when Congress enacted the Clayton Act, it used language whose plain meaning was a quite interventionist. But unfortunately, when some courts use, not all, but when some courts interpret the tend to create a monopoly clause, they often substitute less interventionist language. I hope that the rise of textualism, which gives more of an emphasis to the actual words of a statute, will help the courts, and in particularly conservative courts, to go back to the original interventionist intent of Congress.
Thank you. That's really interesting. And I like the idea of being able to use the textualism to kind of bring the judges around who may otherwise be skeptical.
To say, look at the words of the statute. If you claim to be a textualist,
Yep.
take it seriously. And the guidelines do a great job of this. They're much more textualist than the 2010 guidelines.
Okay, great. So we are running short on time here a little bit. John, is there anything you've heard so far that you'd like to weigh in on or respond to, or if you want to give it some more thought?
I can throw in a couple things real quick.
Sure.
Look, I've talked a lot, but one thing we haven't talked about yet is what isn't in the guidelines. I think we talked a lot about what is in the guidelines, but it is almost, if not just as important to keep in mind what's not in there. One thing that's not in any of the guidelines, the numbers, I won't use the numbers here, is an extended discussion of elimination of double marginalization, which really tended to dominate discussions of vertical merger enforcement for a couple decades. Really kind of sucked a lot of the air out of the room. And I've heard some surprising statements in relation to EDM, boring antitrust kind, not the fun music kind. Like vertical math models don't work unless you account for EDM. That may be true of some vertical math models that have EDM baked into them, but it's just not true that you couldn't come up with a model, right, that doesn't bake in some kind of what we might call efficiency credit for EDM. And I think it's another area, you know, not giving an extended treatment of this, I think is another area where the guidelines really reflect, I think, good law, because there's no case that says you have to take into account some kind of magical EDM benefits, but also good economics, right? And I think John Quokka and Margaret Slade have a nice short lawyer-friendly paper on this where they just walk through like hey, there are actually a number of really unrealistic assumptions that have to hold before EDM will actually materialize due to a vertical merger. That turns out to be kind of like a lot of simple Chicago school stories, a little too simple. So that's one thing to keep in mind.
So just because Perry and I had talked about this, and so I think it would be interesting to have you two maybe engage a little. I think and I think Marissa too, we talked about this. The question of, so to completely omit any reference to EDM in the guidelines, I think some would see that as potentially a mistake, because it, you know, one option would be to include a discussion of it, but say this is how you do it right. But instead, there's maybe a sense that sort of at you, but that we're, you know, we're just ignoring something that is definitely going to be raised by the parties. And so, I mean, like I'm thinking, I mean, I was a clerk, I was never a judge, but I'm looking for the guidelines to guidance on this, and I see nothing about it. And then I think, well, if our agency's trying to like put their head in the sand or hide the ball, you know, what's going on here. And Carrie, do you want to
Well,
say?
so, I mean, I think others have talked about this. My jumping off point was AT&T Time Warner, where Carl Shapiro got, I mean, I think lost the case on EDM because the judge didn't take his testimony on how much prices will go up, but took his testimony on how much would be saved as a concession. And it was based on the same model. And that was like, to me, that was the end of the case. So, to me, the answer is relatively simple, and I'm curious as to what you think, John, is just to put it in as a defense to make it clear that this is not the government's burden. So it's the defense burden to prove what EDM is. Now, and I agree that actually that's not so easy. I mean, in AT&T Time Warner, they didn't have to do that. You know, Carl Shapiro did it for them. So I would much rather have had, you know, the defense economists bring it in. The way it is now, it'll just be cross-examined. You know, where is it? You know, aren't there any savings? I mean, I don't see how that could be avoided. So I think that's a relatively simple fix in a way to put it in as a defense and shift the burden, because you're just not going to get away from that. And I think it's basically, you know, one that's going to be hard to meet if it's written well enough.
Emilio, do you want to quickly jump in?
Yeah, just quickly here. The problem with that is a case called Baker Hughes. And the problem is whose burden it is because of Baker Hughes. Oftentimes, arguments that one would think would be, with all due respect to anybody who's a defense lawyer here, would be the defense burden, ends up becoming the government's burden to refute it. So, for example, on eliminating double marginalization, the question would be under Baker Hughes, if the defense brings it up, does an expert like Carl Shapiro have to knock it out of the water? And what happens if, as Perry is relating, the expert says, well, it's kind of both. Not Carl Shapiro, Stephen Solip has a great sort of exposition on all of the issues with eliminating double marginalization that he goes through as part of his comments on that were solicited as a request for information on the merger guidelines and later on the actual draft merger guidelines. But Baker Hughes kind of stands in the way. And I'm not saying that I personally agree or disagree with Baker Hughes, but it's also come up with like fix-it-first remedies. Whose burden is it to show that fix-it-first remedies will mean that there will be no competitive impact? And the government has found itself often faced with, well, it's actually their burden to show that a fix-it-first remedy won't solve the problem, which is pretty interesting from a government enforcer perspective, that basically the defense can raise an issue and you have to knock it down rather than they have to prove that actually their solution will work. And so I don't think that's going to work, and I actually think, speaking personally, I can understand why EDM was not put in the draft merger guidelines themselves because it would be never ending. Like, for example, if they took, for example, Marissa's article, which now I have more homework to read, or they took Carl Shapiro's work or Steve Salop's work and said, here are all the issues with EDM. You know, it's like that old shibboleth that the Chicago school had, that tying is invariably pro-competitive. And it turns out that's only true if there's like a whole series of assumptions, most of which don't exist in most cases in the real world. And Einar Elhag did a great job of showing that. You have the same problem here. Now, I will say, speaking for myself, if there is sort of the feeling on the part of my federal colleagues that they need to address EDM somewhere, then I think maybe commentary on the guidelines would be the way to go, because then they can explain out, much like Marissa apparently did in her article, where she's now increased my homework. Thank you very much. That for EDM to apply, here are all the assumptions that have to hold. And really, courts need to be suspicious when people bring them up. And when you have a trade-off like Carl Shapiro has mentioned, you know, that's a trade-off. You can't say, oh, I'm just going to credit the savings and not credit the hit because it's all the same model. One final point on EDM. This isn't like some plot hatched by the Biden administration. So if you look at the ABA comments on the draft merger guidelines, they do at least point out that the last head of US DOJ's antitrust division under the Trump administration also said that he thought that EDM didn't necessarily hold in all cases and that you had to have a number of assumptions. So this gets back to one final point, is Oliver Williamson recognized law, and so did Justice Breyer, and sort of the intersection of law and economics. Law is about administrability. And maybe one thing that the lawyers in this room or the law students can do is start thinking about Baker Hughes and how much is that correct or incorrect? Because that kind of scholarship could really help judges not to sort of accept it uncritically and maybe think about what is properly the government's burden, right? It shouldn't be just because we allege something, we win, right?
Emilio, sorry.
But if I could just finish my
Yes,
thought.
of course.
Since other people went on for a long time, I just would like to finish my thought.
Yeah,
Thank you.
Of course.
But at the same time, you know, what should properly be the burden of defendants if, for example, you're going to have an efficiencies defense? Thank you for letting me finish my thought.
Yeah, no, of course. I'm sorry. I didn't mean to interrupt. I just, no, we are running overtime, and that's completely on me. John, did you want to respond? I think Harry had posed.
Harry will just come back to something else and then we'll.
Well, no, I mean, we started a few minutes late. I think we can, I think people can bear with us for just a few minutes more. Does anybody would you like to?
We talked an awful lot about efficiency defenses today. What would a textualist say about efficiency defenses in merger cases? I mean, as you know, what a textualist would do would be you read the plain words of the statute and pretty much stop, right? Well, we all know what's in the Clayton Act. We all know what's not in the Clayton Act. There is no efficiency defense in the Clayton Act. The law does not say you forbid a merger if the effect may be substantially to lessen the competition or to tend to create a monopoly, unless there's a whole bunch of efficiencies. It just doesn't say that. By contrast, the Robinson-Patman amendment to the Clayton Act, Section 3 of the Clayton Act, says it uses the same operative term, may be substantially to lessen competition or to tend to create a monopoly. But then it does provide an efficiency defense. It says unless defendant can show that the pricing was caused by a lower cost of manufacture, sale, or delivery. So Congress knew how to write an efficiency defense and inserted it in Section 3 of the Clayton Act, but not in Section 7 of the Clayton Act. Now, maybe we should just stop the analysis right there and say, it's not there. Where did it come from? And as some earlier speaker said, well, it came from the Reagan administration. They said in the 1982 guidelines that they would listen to efficiency arguments in extraordinary cases. Now, I went into private practice shortly after that. Guess what percentage of our cases we allege to be extraordinary, and everybody's going 100%? Well, of course, that's what everybody did. On the other hand, it's almost never accepted, or maybe even never accepted. Now, one possibility, as Susan might have said, is because the enforcers, in their wisdom, with their discretion, don't bring cases if they created an awful lot of efficiency. Okay, that's a possibility. The other possibility is Mark and a whole bunch of other people at Utah, and I would add Judge Posner to this mix, don't believe that mergers very often create efficiencies. There's a wonderful quote from Judge Posner from 2015. This won't be exact. I wish somebody could show me efficiencies from mergers. There must be some from 2015. Well, okay, now let's go a little bit deeper into the subject. Okay, what about intend to create a monopoly cases? This is the easy one. I'm taking the easy one first. The text says they block mergers which may tend to create a monopoly. Period. There's no exception for an efficient merger, for an efficient monopoly, or an efficient tendency to monopolize. So if we're going to go down the route of textualism, at least for tend to create a monopoly case, and that's exactly what the guidelines do. How many of you noticed that the guidelines do not permit an efficiency defense? Raise your hand. How many noticed this? Okay, a bunch of people noticed it, but not everybody. That the guidelines say no efficiency defense intend to create a monopoly cases. And if you take that seriously, moving in the direction of a monopoly, or moving meaningfully in the direction of a monopoly, well, then that should be very powerful. And I would hope the enforcers would bring more cases under tend to create a monopoly. Now, will the courts accept this? You know, who knows? Okay, now let's go to the harder question. Maybe substantially to lessen competition cases, and centering around the word competition. What did the word competition mean in 1914? For lack of time, I'll reduce it to one sentence, one definition from the Oxford English Dictionary of the time. They're all the same. The action of endeavoring to gain what another endeavors to gain at the same time, the striving of two or more for the same object. Rivalry. Competition means rivalry, and as Rebecca and others have said, this is stressed. The language, the word competition is stressed in the new guidelines. So what does that mean if we're going to have an efficiency defense or not under the maybe substantially to lessen competition? And here it's a really complex and I think maybe ambiguous question. On the one hand, one could argue, suppose a merger would reduce the number of firms from 4 down to 3. Isn't that less rivalry, less competition? Shouldn't we stop the analysis? On the other hand, defendants will surely say, well, what if there's a tremendous efficiency from the merger and that enables the small firm to compete better with the big firm in the market? Isn't that a plausible reading of competition? And that may well be the way that a textualist judge would go. Now, is that enough to offset the overall idea that Congress could have written an efficiency defense and chose not to? That this would be inserting the judge's language into the statute, and textualist judges aren't supposed to insert policy preferences into a statute. Overall, I wouldn't want to make a prediction about what a court would do. I would, sure, yeah. And I'll shut up because we could discuss it over lunch. Good idea.
Sorry. I think, yeah, I think we've got a break here. I think it's been a great discussion. As you can see, the discussion could go on for a lot longer. We have I think one of the bigger panels, so it was tough to get a chance to get everyone's voices. So also encourage everyone to, well, I guess I shouldn't encourage everyone to harass the panelists over lunch.
Sure, absolutely.
I mean, that's what they're here for.
That's why we get paid the big bucks.
Yeah, exactly. So I think lunch is in the right out. Okay. Lunch is right outside, and then you can sit next door if that's it. Yeah. Okay. So thank you all for joining.